Hello, everyone. Welcome to McHenry County's Lunch and Learn. We are here with Natalie Kase, who is from DCFS. She is our Senior Regional Counsel. You may have seen her in the courtroom. She is often there, sitting at the table, kind of hearing and listening and knowing what needs to happen legally. So, yay, we really like to have Natalie around. Natalie, I'll let you go ahead and take it away.
Thanks, Sherry. Hi, everybody. I'm Natalie. Like Sherry said, I'm the regional counsel from DCFS assigned to McHenry County. So if I'm not in a different hearing, I'm usually in the courtroom on Thursdays and Fridays or as the workers request. I have been asked to talk to you all today about the legal screenings that I conduct with the workers when we are getting ready to terminate rights on a parent, or when we've decided that we are going to pursue a different goal than return home. So a legal screening is basically DCFS's way of making sure our I's are dotted, our T's are crossed. It is a comprehensive review of what has happened so far in the case. So when a worker notifies me that a case is ripe for legal screening, there is a huge checklist that my paralegal Elaine sends to them, basically asking for a number of forms, all of the court orders in the case, copies of the children's birth certificates. There's a nice long list of things that need to be turned in before we can even bring it to screening. Sometimes that means that I need to get copies of orders to help complete the file. But it is more or less, it's all the documentation that the state is going to need if they are going to a termination of rights, or it's going to be a compilation of things that the subsidy is going to ask for if we're going to guardianship. So I'm kind of like the gatekeeper, making sure everything is there, making sure that we've made the appropriate findings, we're on the right set of timelines. So it's kind of like a check and balance. Like the state can certainly proceed to termination without us passing it legal screening, but it's kind of more of a courtesy that they wait. And I'm sure you've heard it in court with Judge Harmon asking if we're going to go to legal screening before we change the goal and before the state files their petition, which is a nice courtesy that we have in McHenry County. It's not always the same in other counties. So when all those things are compiled and ready to go, I screen all the cases for McHenry County. So I work with all the placement workers on discussing the case, and then I either pass it or I fail it. And I do occasionally help out in Lake County because they have such a high volume. So what you see on the slide here is kind of where I start with everybody. I ask the worker, tell me about the case. What circumstances brought the case into care? You know, is the main issue substance abuse? Is it domestic violence? What kind of brought this case to the attention of the department? I also ask who or who is not involved. How many parents do we have? Who is participating? Who has disappeared off the face of the planet? And then for those parents who are not available, I make sure that we have a recent diligent search on an absent parent so that they know that this case is going on. The state usually, if the parent has been absent, the state will usually be required to what we've referred to as publish. So that's also kind of like a check and balance. We're going to see if we can find them. And then when the petition's filed, the state will see if publishing kind of gets the parent to become involved again. And then for those who don't know, a diligent search is basically the worker, you know, performing a formal search about last known addresses and trying to reach out to them at a last known address so that, you know, we can say, hey, you know, we tried to reach out to you. It's kind of a CYA in case they pop up during termination proceedings. And like I said, the state will usually, if we have an absent parent, publish, which is an official way of giving a legal way of giving somebody notice to a proceeding that would affect their rights. So we can all say kind of like we've done it twice, tried to find you, and we're at this point. Next, after we've talked about kind of the circumstances of the case and who's involved, I'll kind of go through the worker like, hey, what was mom asked to do? What did she do? What did she not do? Same thing if dad is involved. What did he do? What did he not do? And why were these services the recommended services to address this issue? I'll also ask if there are other things, maybe it came in for domestic violence, but we didn't realize that, hey, there's a substance abuse problem here. I'll ask about that. Like, how did we find that out? What services were complied with? What services were not complied with? I'll ask when they were completed, and usually there needs to be proof filed with the court so that it's noted on one of the orders that it's been completed, and it's noted in the service plan that it's been completed, and I'll see when. I also take into consideration whether or not those services were completed before or after the goal change. And I usually see that more in Lake County. Like I said, in McHenry County, the court is usually very good about waiting to change the goal until it's past legal screening. Lake County is not the same. Usually once the personnel have decided that this is a case that can't be a return home, they'll just change the goal even if we haven't completed legal screening. But at that point, then I can consider when those services were completed. It's usually not an issue in McHenry County. And what that tells me, I'll kind of address on the next slide, is that we have certain timelines when things need to be completed. So I look at how long the case has been open. If we're, kind of to jump to my next bullet point, I can't legal screen something less than 9 months post adjudication hearing. So the longer we take on the front end before adjudication, the longer we have to wait until it can actually go to legal screening. There is an exception to that. I have only seen it requested in one case, and it can be an expedited termination for legal screening, which would happen before adjudication. And that is like a super extreme circumstance where, for instance, a minor has passed away as a result of a neglect or abuse. That is a super extreme circumstance. Most every case that comes through court is the typical, we have to wait until 9 months after adjudication. So it will automatically fail if that timeline hasn't been met. I also need to see that the most recent service plan is generally rated as unsatisfactory. There may be some pieces in it that are satisfactory, but overall, the service plan has to be rated unsatisfactory. And then I ask the worker why these were the services that were recommended. These are the ones that are outstanding. Like, why are certain things completed, certain things not? We have a nice discussion about the engagement of the parents and why we have chosen to rate a service plan as unsatisfactory. So then I also need to see the most recent permanency order having no reasonable efforts and no reasonable progress as to the parents. Those are, I'm sure you've heard Judge Harmon say those are two different things. One is subjective and the other is objective. I personally like to see both when I'm looking at a legal screen, but I'm only required to consider the objective standard. So, if in the past 6 months, because permanency hearings have to be held every 6 months, if in the past 6 months there's no efforts, no progress, that's a stronger argument to me than just no progress. Another thing that I have to consider is if the minor has been in a permanent placement for 6 months. So we may meet all these other check marks, but the minor is, for instance, in residential, and we don't know where the minor is going to be placed once they're discharged. We have to make sure that if we're passing legal screening, that the minor is going to have a home to go to once, you know, they're released from the hospital, for instance. And then we also kind of, 6 months is the statutory length, but it is that way so that we can make sure that there's no disruption in that placement. If we are talking about a subsidized guardianship, this has come up as an issue. The minor may be placed there for 6 months, but the foster placement needs to be licensed for that 6 months of time. So I won't fail it. I think we've all kind of come to the consensus that it's not going to fail if the minor has been there since case opening, but the foster parents have only recently been licensed. But the guardianship can't proceed if the license hasn't been active for 6 months with the minor in the home. So that's something that I have to consider when we're talking about a subsidized guardianship. I also review and make sure that the names on all the court documents match the names on the birth certificate. Because then in order for it to pass, I need an AKA, what we call an AKA order, which just notes that maybe the minor's I've had circumstances where the last name on the court documents is not the last name on the birth certificate. So we need to get an AKA order so it's clear that this is the same minor when somebody is looking at the paperwork. So those are most of my timelines when I'm looking at, like, these are kind of the bright line rules. Like I can't accept any exceptions to these rules. Like it needs to be 9 months since adjudication unless it's an expedited. I need to have an unsatisfactory service plan. I need to have permanency orders that have no reasonable efforts or progress. I need to have the minor in a permanent placement for 6 months, and then all the court documents need to match on the birth certificate. So usually I take care of this portion like just prior to speaking with the worker, because this is all stuff I can understand from the paperwork. And now the last thing I do is I kind of delve into the permanent placement of the minor. What kind of foster home is it? Like I said, is it a licensed foster home? And then, as I noted on the last slide, I need to make sure that that foster home is licensed while the minor is there for at least 6 months. I want to know who the foster parents are, where they live, if they have any relationship to the minor and their family, or if they are a true traditional foster placement. As part of the paperwork, the workers have the foster parents submit to a background check. Is there any concerning information that I consider kind of in a totality of the circumstances? I've had foster parents have drug convictions from, before I was born, and nothing but a traffic ticket since then. That's not going to concern me as much as maybe a more recent conviction for something like that, because it raises a red flag for me. Like, that's probably not going to be a permanent placement if we have ongoing criminal activity, even though it may not be directly related, like a child endangerment charge or a domestic battery charge. It kind of makes me probe a little bit more about why that permanent placement is the most appropriate if they're risking some kind of punishment, criminal punishment or sentence. So something like that. I kind of consider the totality of the circumstances. Another big issue for me is that is this foster placement willing to allow the child to maintain appropriate relationships with the biological parents or any extended family or siblings, if it's appropriate. I will ask the workers if they've discussed with the foster parents enforcing that boundary if need be. Oftentimes they're the supervisor of the visits in the case, and that's something that's occurred before where foster parents have had to turn down a visit because the parent showed up high or the parents were arguing, so the visit had to be terminated early. Usually I can get an idea if that is going to be an issue. And like I said, siblings, it's a rule in the case, and it's something like we like to be reassured post legal screening that the siblings will still be allowed to have a relationship and visit with each other, again, if it's appropriate. Ultimately, I will say, ultimately, it is the adoptive parents or the guardian's decision whether or not those family members are allowed to have access to the minor once these proceedings are completed. But usually, like, I look at the totality of the case. If they have been cooperative with allowing the parents to have contact with the minor when appropriate, and they've been facilitating the sibling visits, I don't have as many concerns as if they have been difficult facilitating those things to the life of the case. I don't think I've ever turned down a legal screening because I didn't think that the foster parents or the placement was inappropriate. That I leave that as a social work decision. I'm just looking at it from a legal perspective. So as long as there is a reason and a documented reason for this family being an appropriate placement outside of the timelines, I usually do not deny something based on a social work decision, as long as there's a reasoning behind it, if that makes sense. Lastly, I kind of start the workers thinking about this. The foster parents, if they are older than 55 or 60, I can't remember which one it was, but if they're close to retirement age, for a subsidized guardianship, they'll require the name of a backup caregiver as part of that permanency planning. So I usually try and encourage them to start that conversation before it gets to the subsidy stage. Like, hey, don't like to be morbid, but do they know what the plan is if something happens to them, especially depending on the minor's age? It's something that, I will just generally ask them to consider and discuss with the family. Just to make sure, there's we try and make this a permanent placement. We don't want them to come back. I understand that's a fact of life. So if there is someone who is willing to step in and care for the minor, if the new guardian or the adoptive parents pass away, that's, I would rather have that than the minor coming back into care. So that is kind of like my basic roadmap. It seems short, but as I'm sure you can imagine, like, a lot of the content, a lot of the questions are prompted by the information that the worker is giving me. So usually as they're explaining kind of how the case has progressed, I have more questions from there, but these are kind of the main three buckets that I need to make sure that we have reasoning for and have met, basic requirements. But more or less, the legal screening itself is basically a debrief of the entire case, and a conversation with the worker and sometimes her supervisor. But that is what I consider when deciding to pass or fail a legal screen. And then once I decide if it's going to pass or fail, I let my paralegal know. And for termination cases, because this is essentially all the paperwork that the state is going to need to file their petition, she will send it off in hard copy to the state's attorney's office. But for a subsidized guardianship, from there, once it's approved, then it gets referred. We have a new pilot program. I used to file the subsidized guardianships for the state, but now none of the regional councils do that. There is a list of guardians, like there's a list of attorneys for adoptions, and the family gets to choose who's the best fit for them, and they will file it for me instead because they don't give me enough to do. That was very nice of them to take that off my plate. So it's still a pilot program. It's only about a year old. So I know that there have been a couple hiccups in McHenry County getting that scheduled just because of the way that the clerk's office operates. So I've reached out on those cases to kind of prod it along and give them the private attorney direction how to get it filed and get it heard downstairs. But it does take, the guardianships take a little bit of time because of the licensing issue and because of the pilot program kind of holding them up. So that's usually the cause for the delay related to those, related to the guardianships. So that is all I really had, because that's kind of just, it's a really simple process. Like I said, it's more about like the conversation that I'm having with the worker and the information she's giving me specific to that case. So if anybody needs a little bit more clarification or has questions, I'm happy to take those now.
All right, thank you so much. So you can pop on and ask a question. You can put it in chat, whatever kind of works for you guys. As you heard all that, what were things that were questionable in your brains about, maybe about your case, maybe just in general?
The thing that struck me initially was I didn't realize you existed. So this is really very interesting.
Hello. I have been with the department for about a year and a half now. My direction when I was hired on is to try and be as present as possible. I think across the board, DCFS wants the attorneys to be present and to be able to support the court personnel, because oftentimes, like, as we've seen it come up in court, we're like, can DCFS really do that? Like, do we have any resources for that? Right. So prior to me, I know Pete Gruber was covering McHenry and Lake, which is a lot. I think even having one full-time attorney over in Lake is not enough. So he was there if like somebody would shoot up the firework and be like, hey, we really need you. And then before that, I know it was Deb Stone, who was more of a hands-off type attorney. So yes, I am around, and I'm happy to help and answer questions and come talk to you guys. Can
I ask a real simple question for you?
I'm sorry?
Could I ask a real simple question for you? Sherry in our training was very adamant that we do not change the service plan, because that's unfair to the natural parents, because the barrier keeps moving up and down. We're doing that right now in our case, and I'm worried, I'm concerned, and I hadn't heard that it was going to you for review. So I know the revision has been written. I haven't received a copy, but it's probably going to the judge. Will the judge kick it back to you?
Yeah, so, Natalie, can you kind of explain the difference between the service plan and minimum sufficient level of care? That's the part I think that we're thinking about in class.
So do you mean, what do you, I guess, the service plan is kind of like the case plan.
Correct.
It can be changed because, you know, like when we're doing investigations, when the hotline calls come in, sometimes we uncover issues that we didn't know existed that need addressing before we can feel comfortable returning the minor home. Sometimes they're very intertwined, like domestic violence and substance abuse, and we don't realize that one is feeding the other when the case comes in. So the service plan can be updated, essentially. But if you're talking about changing the goal on the service plan, which I think is what you're asking, like changing it from return home to return to guardianship or to termination.
No. This is a return home.
Okay.
Yeah, that is, they're not necessarily trying to change it, but they are trying to increase the bar to make things more difficult for them.
I'm going to give the lawyer answer. So
Pardon?
I'm going to give the lawyer answer. So without knowing specifically what's going on in your case, I probably shouldn't speak to why that may or may not be appropriate, but it can be updated.
Okay.
But
Okay.
that also those updates have to be approved by the court as well. So
Exactly.
the judge may say, no, I don't think that's appropriate in this case. Like, we're not going to do that. Or they may look at it and be like, yeah, I think that's a great idea, and approve it. So it can be updated, but it still has to be approved by the judge.
Yeah. Well, the judge actually requested some of the changes, so the judge seems to be on board with that.
Okay.
But now the
Okay.
judges have changed, so now I don't know what the new judge is going to do. So
None of us do. I'm still trying to kind of get an idea of what she prefers and what she doesn't.
right.
So
Right.
So we'll all be surprised
Sure.
what she decides.
It's good for surprise.
Yes. Sometimes. So
All right, Natalie, could you talk a little bit about subsidized guardianship? What is it? When do we choose that versus adoption, et cetera, things like that?
So there are two types of guardianships. There is a subsidized guardianship, which is the more common option. And that is when there is, a monthly stipend, essentially going to the guardian to help offset the costs of care for that minor. Just a true private guardianship is not subsidized. It doesn't go through the department. I think we've been using it more recently on cases. I know that there's like 2 or 3. And that is either guardianship is used or preferred over an adoptive case. Typically when the parents are kind of just barely moving forward, but they're not quite making progress, like by that standard. They might be making efforts, but it might not be enough to call it progress. And so this is also a situation where this case might have been open, in 2019, and we're still not there, or we're looking at, a parent who really struggles with sobriety, for example, because that is an ongoing personal hurdle to try and meet. And so they may be making those efforts to stay sober, but they're not making progress towards the actual return home of the minor. For a private guardianship, I am not involved at all. That is a situation where the parents, and I do have a situation where the parents are substance users. They know that this is going to take some time. We are not quite at the point of adjudication, 9 months post adjudication, where I could potentially consider it for legal screening and a subsidy. And this foster parent is like, you know what, I don't need it. I can take care of the minor without needing a subsidy. And in that case, that's when the parents retain their own separate counsel. They file it separately. It does not have to be on my special little list of approved filers on behalf of the department. I don't have to do a legal screening for that. It is entirely a different animal. Same result, but I'm not involved, or the department is not involved whatsoever.
Okay.
A subsidized, sorry.
Okay. That sounds good. Thank you.
I was going to say the subsidized guardianship is where I have to do the legal screening, and then I have to send it or it gets sent to the subsidy unit after I pass it for legal screening. So then that's when we are involved and we do have that list. And the main difference is just money. We can kind of skirt around those timelines if everybody is in agreement for the private, but for the subsidized guardianship, we have to go through everything that I just explained.
Okay. So I know one of the things we talk about as CASAs is that we push more for adoption than the subsidized guardianship because of its permanency aspect, and that the idea of guardianship is that it's still open, so that if the parent does is able to become better at whatever they need to do, it disrupts the child again, potentially 4 or 5 years down the road. What's the DCFS comment about that kind of thing?
Well, they, we like to explain to parents that it is not permanent. And that's usually in an effort to get the case to move forward with that goal. It is not as easy as we explain it to the parent. A guardianship, you still have to open up a new court case if you want it extinguished. Like, you'll have to reopen it under the guardianship number. You'll have to have an attorney, most likely. That attorney will have to show, it's their burden to show that this person now meets minimum parenting standards and the guardianship is no longer in the best interest of the public or the minor, that it continue. So it's still, we try and say, it's not permanent. It's, we can undo it in the future if you get to where you need to be. But don't forget that it is still a true court process you have to go through and show why you're able to now care for this minor. So in my experience here, I haven't seen any guardianships be petitioned to be vacated. I don't think, even previous to me working with DCFS, I was a public defender, and I don't even think then I saw any guardianships petition to be extinguished. And usually I would guess that that's because the guardian is allowing that access to the minor as long as the parent is appropriate. Especially because usually guardianships are also like some kind of fictive kin, some sort of extended family member, a family friend. So that relationship is still there. The access to the minor, if appropriate, remains. It's just they're not the full-time parent. And I think that's why they generally are not requested to be extinguished.
Okay, thank you. And we're asking, how long does the legal screening process typically take?
It's usually the front end of getting all of the things on the checklist. That takes the worker a bit of time because they have to make sure everything's completed and scanned in and sent to Elaine, and that, among their other duties, that takes a little bit of work on the front end. The legal screening itself usually takes me about half an hour. It's an appointment, and I try and get those scheduled as soon as I have availability on my calendar. I know not other counties are as accommodating as I am, but especially if I know from being in court that this is something that the personnel are really waiting on and really hoping to see soon, I try and get it as soon as it's ready to go. I try and get it on the schedule as soon as I can. After the legal screening passes, like I said, it depends on the length of time, depends on how quickly they can pick out an adoption attorney and how quickly the subsidy gets approved, or if there is more time that's needed for the foster parents, the potential guardians, to be licensed while the minor's in the home. So it can take some time afterwards based on a number of factors, but for my portion, I usually try and get it within like 2 weeks to get heard and done once the packet's together.
Okay. Is there anything that CASA does that can be helpful to collecting paperwork and things that is something that is inside of our role?
I would have to defer to any caseworker on that. If it's going to be sent to legal screening, certainly offering the worker any assistance that you can provide is helpful, because for the most part, I'm hands off until the appointment. It all goes through my paralegal, and I really don't think she minds how the paperwork gets in as long as it's incorrect and all together. So I would defer to your individual workers if there's anything that you can do to assist getting those things together.
Okay, good. Another question about guardianship. There's something recently that we heard about when they turn 12 years old, it doesn't need to be a licensed guardianship or something. We're very unclear about what the new,
The new rule is,
yeah.
well, with age, as far as the final goal, I think it's 14. They have to consent to one or the other.
The
I
child.
think that's the child. Yeah, once they're 14, they get a say if they want to be adopted or if they want to go through with a guardianship. I am not sure off the top of my head what the rule is for the answer to your question. I've still been screening it like there needs to be a license. And usually I think the push is to have everybody who's not a traditional foster placement get licensed, just to have a catch-all. So I haven't seen that issue come up quite yet. So I'm not familiar with that rule, that
Okay.
new rule.
All right. Question to go back to, you talked about how services were completed before and after TPR, and it's not really an issue here in McHenry, but we do know we have a new judge in our courtroom. Can you talk a little bit about what that would like if she chooses to operate differently?
So basically, if the judge is not going to wait till it passes legal screening to change the goal, I can't consider what services were completed after the goal changes, because now it's no longer return home. That progress that you make at termination is great, but it wasn't in furtherance of the original goal. So essentially, if the judge decides to change the goal, and the state and I work very well together, luckily here. So if the judge starts to hint at that, I think Brett or Marianne would say, hey, judge, it hasn't passed legal screening. We have to wait for that.
Okay.
But it basically would cut off if the goal changed prior to legal screening. I couldn't consider anything that happened after that. So it does a disservice to the parents and the family, really, if I can't consider everything that they've done.
Got it. All right. I'm going to read this one because it hasn't sunk into my head yet. Does a natural parent's mental or drug-related incapacity that caused the TPR in the first place delay or cause legal screening to be fast-tracked?
So I think what this person is asking is kind of that expedited termination question.
Okay.
Usually not. Like, I can consider, when I look at mental illness, I have to look at it through the lens, and the social worker should be looking at it through the lens. I think a vast majority of people do have some kind of mental issues that they need to work on. Like, therapy, I think, is becoming a lot more prevalent, but it has to interfere with their ability to parent and contribute to those minimum parenting standards for the minor. Like I said, it has to be extreme. Like, there's a minor in the home that passed away as a result of neglect or abuse. That's really kind of the standard for doing an expedited termination. Everything else is on a typical 9-month post-adjudication timeline. So while I can consider, obviously, substance abuse or mental illness, I have to look at it through that lens, but it's not going to be a requirement for expedited termination.
Good.
Got it. Very good. All right. I think I have asked all the questions that have come in. Anybody else have anything else they want to ask? All right. I think it is slowed down, Natalie. This has been really, really insightful. I know it's something that you're thinking, hey, it's a checklist and I just kind of do it. But really, we're not exposed as CASAs so much to what's going on behind the scenes, and it helps just to know, even if it's not something that we are really part of helping to do, we could just sort of know. And when folks are asking us, hey, it's going to legal screening, at least we have a little bit of an understanding to understand why it has to go through this process, so that the checks and balances are made. And we do really appreciate having that information. So,
Of course. Yeah. Happy to have the chance to come speak to you guys and, even answer some of the questions that you have, not necessarily related to screening. So if my card is in the courtroom and I'm usually there Thursday and Friday mornings. So if you do have questions, you can always pull me aside and I'm happy to help.
all right, wonderful. Well, thank you, Natalie, for your time. And CASAs, it's good to see all of you. Make sure you get your hour of CE logged. We'll probably put this under the juvenile courtroom. All right, take care, everyone.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Meeting.